we didn't get any further, no statement, no questioning. It was just kind of making sure that she did not hit her head at that point.
Did you see any injuries on her head?
Not on her head, no.
The only injury you seen was on her finger.
She was,
So, is it safe to say you don't know why she was feeling the way she felt, or?
that is correct. I could not tell you why she felt the way she felt.
All right, thank you. No further questions. Yeah.
Can you redirect?
No, Your Honor.
All right. Thank you, Jeff.
Your Honor. No further witnesses for the people, Your Honor.
Right.
Witnesses, yeah.
All right. All right.
Next one.
Well, what do you want to do?
Well, I'm gonna ask
Well,
you-
what do you tell me?
All right, we'll do this.
No, you don't tell me. Go ahead. Do the next case.
Do the next case?
You want to do the bind over on this one?
Please.
Go ahead.
Okay, Your Honor, at this time, the people would motion for bind over. The court heard testimony from Deputy Gerwig saying that she's reported an incident where the defendant slammed the victim onto the ground, making her hit her head and lose consciousness. The court further heard from testimony that after this event, she had a cut and also was unable to hold up her own body, hold up her head, incoherent from this injury that she sustained from the defendant. The court further saw body cam footage as well as the in-car footage of the defendant resisting the arrest of the officers, refusing to put his hands behind his back, tensing away, refusing to walk to the car, fighting with officers, while he was being arrested. The court also saw in the car the defendant spit on the car multiple times, as well as kicking out the window and causing extensive damage, over $2,000 to that car. So I believe we have met the burden of probable cause in this case to ask the court to bind over.
Response.
Respectfully, Your Honor, when it comes to the assault with intent to do great bodily harm, domestic violence, my client, first of all, we don't have.
This is where the hearing shifts from evidence to legal strategy. The prosecution believes there's enough proof to move the case to trial, but the defense isn't trying to prove innocence here. Instead, the goal is to show that the evidence may not legally support every charge the prosecution has filed.
In that situation, unfortunately, I can't cross-examine anybody to find out what was going on. We do hear on the phone where he said, he picked her up, my client, picking his print up and slammed her, but we don't know what that means. I can't cross-examine him and say, how was that? Was she trying to hit him? Did he grab her? And that happened. Was it in self-defense? We don't have any of that in front of us, Your Honor. Respectfully, when it comes to the resisting obstructing police officer, I think we got one resisting obstructing for the most part. In Michigan case law, it has to be an individualized attack on each officer when they charge it in different counts. In this case, this was one situation which a group of officers were attempting to arrest my client. It's not like he kicked one officer, punched another officer. It was one big, and I wouldn't even say it was assault. It wouldn't even go to the assault part, more the resisting part. He was potentially resisting arrest. He was actually frightened, and I wouldn't even call it resisting arrest. He was just frightened. But if we're gonna call it that, he was frightened arrest from multiple officers at the same time. So I would just say that wouldn't be against four different officers. Is one.
Do you have that case law?
I do, Your Honor. I'm glad you asked.
All right.
Give me 1 second. A lot of research on this case.
Okay. Only does you good if you can find it.
Say,
Nothing. Yeah.
oh no, I wouldn't lie. I want to.
No, I know. I'm just asking. You need to show it to me.
I know that. We do got. Is there internet I got on here?
Pardon?
My I need my internet to work.
No. I don't know. Mine's working. So you can't. There's a public access. You should be able to access it.
I can put it on. Usually I got cellular then. But my internet is
You said
I'm saying that that's not working.
Did you get your internet?
I did, yeah.
Okay, good.
I'm looking for it. I guarantee you I got case now.
Okay. Okay. Somebody was. No.
If you go to people anymore, 314 Mishap,
314 mishap.
399, 2016.
And what's it say?
It says, the holding is multiple counts of resisting obstructing where appropriate, where the defendant committed distinct acts against multiple officers. Let me see, first two convictions where the conduct was one continuous act affecting multiple officers.
Sounds to me like you said it's appropriate then to charge.
It's not. It's not appropriate to charge, Your Honor. And the ethnic intimidation, you really can't do that because with ethnic intimidation, he didn't do it act because Mr. Guru.
I think actually Deputy Gerwig, he stated accurately it would not amount to ethnic intimidation.
Right. Now it was a
It
horrible
was
thing.
absolutely reprehensible and hurtful and
I-
on the pale in terms of what another human being should say, but it may not constitute a crime. You're right.
I agree. So I think we only got about one count of resisting obstruction. Resisting obstruction. At the most, no ethnic intimidation, and we don't have witnesses here in which I could cross-examine anything that was being said. The biggest thing we heard is that they both were fighting. That was consistent. That was consistent in the report from Deputy Gerwig. That was consistent in the statement from off of the 911 call. We did also hear that he picked her up and slammed her. Well, we don't know the reasoning behind that, and we don't know what that means. I'm not able to talk to Mr. Printup and say, did he pick her up because she was hitting on him like this and dropped her? I'm not able to do that, Your Honor. So respectfully, we're asking to not bind over all the charges, but I would understand if there is one resisting obstruction charge.
One,
At this point, the courtroom is focused on a narrow legal question rather than the facts alone. The defense argues that one continuous struggle should count as a single offense, while the prosecution views each separate act of resistance as a distinct crime. The judge's interpretation here could significantly affect how many charges move forward.
okay.
One, I understand in the malicious destruction.
At what point are we talking about the resisting obstructor? Are we talking about in the hallway where at least I saw 3 distinct incidents? Are we talking about going down the stairway, which once at the bottom I saw another incident? And or are we talking about at the car when when he refused to follow the officer's instruction?
I would call that.
Which resisting and obstructing would you say is the one?
I would say, well, I can't say. I say if anything. That's why I put if anything. But I don't see 3 different distinct acts, Your Honor. I see it all as one continuous act of the police trying to arrest him and put him in the car. That's how I see it. Once they got the cuffs on him, they got him up. He walked down.
Okay. Okay. Yeah. I see how you may be looking at it. I think you're wrong, but okay.
Right. That's how I'm looking at it. Respectfully, that's what we ask, you know.
All right. Anything, I don't need any additional argument, but is there an argument for the people?
nothing but pizza.
All right, the court, after all of the evidence in the case and seeing the exhibits and the videos, would find that the people have indeed sustained their burden as to the majority of these counts. As it regards count 1, the assault with the intent to commit great bodily harm, less than murder, not only by the statements, but also when Deputy Smaha shows up afterwards, her interaction with Miss Printup buttresses that case of her getting dropped on her head, because first of all, she has a cut. There's the blood that's in the apartment, but then also, um, as described by Officer Maha, her inability to carry on a coherent conversation. And as the deputy indicated, she was looking to destabilize her head. It's obvious that something had occurred given the statements that were made. I think that people could show, and a reasonable fact finder could conclude that there was an assault with intent to do great bodily harm done on Miss Printup by this defendant. So therefore, the court will bind the defendant over on that charge. Count two, the malicious destruction of fire and police property. I don't think should be any dispute. One can watch the video and see definitely that that's exactly what he did. He did almost $2,500, $2,600 worth of damage to that vehicle in his little fit of rage that he went into. With regard to the resisting and obstructing, it's contained in counts 3, 4, 5, and 6. The court, while understanding what the defendant is saying, if it were this one event in there, it could be charged as only or properly found to be only one. But when one looks at the video, one can either do this by officer or the separate events that this defendant engaged in as they are trying to take him into custody. As I indicate, you just need to look at the acts of the defendant and what the officers had to do, because there are some officers that aren't even engaged with the initially, but have to then engage, which he then resists, that are happening in that hallway area or that vestibule area. There is then additional resisting and obstructing as he's coming down the stairway, and other officers have to jump in to try to get him to do that, particularly when he gets outside. He is walking after they've had to carry him down. He then goes into another event where he stops moving, and they have to then move the officer. The officers have to move him. And then finally get him to the vehicle. Sitting there, they are trying to get him to just put himself into the vehicle as they have sat him in the doorway. And he is refusing to do that. And then the officers have to re-engage with this defendant to then put him in. So whether it be by officer or whether it be by event, as the court has laid out, I think the charges of resisting and obstructing, and quite frankly, I think that there could be more, but I will bind the defendant over on 4 counts of resisting and obstructing. With regard to,
The judge draws an important distinction here. The court strongly condemns the defendant's remarks as offensive and unacceptable, but explains that moral condemnation alone isn't enough for a criminal conviction on that charge. The legal standard still has to be met, illustrating the difference between conduct the court finds reprehensible and conduct that satisfies the elements of a specific offense.
color growing up in this country, I don't even know how you get there. Don't know how you get there. But I don't think it fits the crime of ethnic intimidation and won't bind him over on that charge. The defendant is bound over on counts 1 through 6. You know what? You better check your client. Take him back. Bind him over. We'll call the next case up after you check him.
Want me to go off before I say something? Okay, yeah, I'll go off.